Hello, I'm Alistair Holzhauer-Barrie, one of the Senior Associates at Gill Jennings Every. Welcome to our Introduction to Patents talk from our series of expert talks on intellectual property IP. We've split this Introductions to Patent talk into 3 parts, of which this is the 3rd and final part. If you've missed the 1st and 2nd parts, you can find these on our website. An overview of what the 3 parts have covered is that in parts 1 and 2, we've covered what a patent is, why you may wish to apply for a patent, and how to identify when an innovation may be patentable. For this part, I'll cover what goes into a patent, the process a patent application goes through to get granted, and how the patent can be used once it is granted. The document that forms a patent, the patent specification, is made up of 2 or 3 key parts. These are the claims, description, and usually, but not always, drawings. The claims define the invention to be defined in the patent in as a generic a way as possible. By defining the invention generically, the boundaries of the area the patent can ultimately protect are pushed out as far as possible. This makes the legal protection offered to the owner of the patent as wide as possible and makes sure that it ultimately arrives at the correct breadth, not being too narrow and not quite encompassing everything that the owner of the patent does, and being wide enough to give the owner of the patent some elbow room to operate whilst competitors may be trying to muscle in and sort of make use of what parts of the innovation and invention they can. The most generic claim is typically the first claim, which is then followed by subclaims that add detail or additional features to the definition. These act as fallback positions in case a patent examiner believes the scope of the first claim is too generic or needs more detail, which is often a case in terms of a process that goes through during examination of a patent. The description is there to provide detail on how the invention is put into effect, how it is made up, and to tell the story about how the innovation was arrived at. There is a trade-off that comes from a patent giving the owner of that patent a monopoly right to stop others from using the invention. This is that the patent must tell others how to arrive at the invention and how to put it to use. This is what the description is intended to do. The drawings accompanying the description then provide illustrations to help demonstrate points made in the description. All in all, the specification has to be set out in a clear and concise manner to allow someone else from the field to understand what is going on. If a patent does not do this, it will be typically very challenging to get a patent granted without it. The process by which one goes about trying to get a patent can be quite a mystery if you've not used the system before. This process and some approximate timings are set out here. First, once the patent specification is prepared, which I'm sure patent attorneys all over will tell you can take some time, the patent application is filed. This day 0 date is referred to as the filing date and establishes the date before which publicly available matter can count against the patent application for novelty and inventive step and any other assessments that those documents could be used for. In the UK and before the European Patent Office, the patent application is searched and the results are typically issued by the Patent Office within the first 12 months. Here the Patent Office examiner is looking for publicly available matters that may be relevant to the invention. The search results typically give the owner an idea of whether their invention will be patentable in the eyes of a patent office. 18 months after the filing of a patent, the application is published. This means the contents of the application are made publicly available at that stage. If the application is stopped before this date, the invention will not be published and can be kept secret, which at times can be important or can be a particular strategy that someone is trying to take. Following the search and up to grant, the patent application is examined. During examination is when the examiner considers all of the requirements of patentability that I've set out in the previous parts of this talk and decides whether a patent can be granted. The period of time over which a patent is examined can vary greatly from case to case and from country to country, so you have to take things as they come with this and keep on top of things. Only once a patent is granted can the rights a patent gives be enforced. As I mentioned in part 1 of this talk, a patent then expires after 20 years from the filing date. subject to the payment of renewal fees throughout the life of the patent. The process I've just outlined on the previous slide is typically what would happen in a single country. However, a significant number of patent applications get filed in multiple countries for the same invention. Which countries to pursue patent protection for an invention is really a commercial decision, and this decision is usually best made when it takes into account the markets in which there will be most sales of the invention, where the invention will be manufactured, and then where competitors are based, manufacture, and themselves have significant sales. To avoid an application in one country causing a problem with novelty and inventive step for an application for the same invention in another country, it would be possible to file patent applications simultaneously for an invention in all relevant countries. This would, however, be quite a costly exercise, especially since the patents would need to be filed before the invention is public, and so before it is itself capable of generating any revenue for the company, and also before a company knows which countries will be important, possibly. To allow for this, typically only a single patent application is filed on the day zero date, on that filing date. 12 months after the first patent application is filed, hopefully after the first search results are issued, one or more further patent applications are filed, so that an invention can be publicized and marketed after the first application is filed. These later patent applications for the same invention are linked to the first by what is called a priority claim. This is possible as long as those further patent applications relate to the same invention and allows the novelty and inventive step assessment for the later applications to use the day zero date, that filing date of the first application, as the cutoff point for assessment of novelty and inventive step in relation to publicly available documents, instead of any later date. Even after 12 months, which countries will ultimately be important to provide protection for a particular invention can still be unclear. If more time is needed, this can be bought using an international patent application, also known as a PCT. Using a PCT provides an extra 18 months to work out which countries will be most important. It's worth noting that this international patent application does not get granted. There is no such thing as an international patent. Instead, the PCT gives the option for pursuing patent protection in over 150 different countries. The countries that option is then exercised in will each examine the patent application themselves and decide whether or not to grant it based on whatever the local variations on the requirements for patentability are. And it's the owner of the patent application that decides which of those countries to take the patent application forward in. The strategy that will be most effective for a company for their patents can change from patent to patent, so needs to be considered for each new application. It is possible to apply a general strategy to a patent portfolio, but you need to keep in mind that there will occasionally be patents where you need to adopt a different strategy, so this just needs to be considered carefully. Once you've got a patent granted, you are able to enforce it and exercise your monopoly right. This usually comes through either seeking to stop people through patent litigation or through using your patent as a deterrent. You do still need to be careful, however, because some countries, including the UK, have provisions that protect innocent parties against unwarranted threats of patent litigation. You can, however, leverage your patent to gain advantages, stop competitors using your patent and that deterrent that I mentioned. You can also license rights under the patent to gain revenue or mortgage it to provide funds for something else. On grant, you also gain the right to mark your product embodying the invention as patented and provide the patent number alongside that. Seeing this marking itself acts as a strong deterrent to others. You should only do this when you actually own the patent, and this is because it's actually an offence to claim that you've got a patent granted and have provided a number alongside it when in fact you don't own that patent. In most jurisdictions, to be allowed to continue to exercise your monopoly right and make use of your patent, a regular renewal fee is payable. This also occurs before grant in some places. There is therefore an ongoing cost to a patent, so how long you keep that patent needs to be assessed against how much use the patent is providing you. And this could be, you could review it on an annual basis or just generally keep it under continuous review. I should also note that in this area of renewals is where a number of scams can occur, with nefarious companies writing to IP owners, informing them that there are fictitious fees, in fact, that they must pay to register or renew their IP. If you ever receive a communication about your IP you are not expecting, always check with your attorney or with a genuine patent, trademark, or IP office who can tell you if the communication is legitimate. Ultimately, the use of a patent is of the owner's own making and can provide substantial benefits to a business. If you're interested in learning more about patents and other IP, you can look at our website. I would also be happy to answer questions via email or connect with you via LinkedIn. I have really only scratched the surface of the topics I have mentioned today, so take a look at the other parts of this talk and upcoming sessions that will cover other IP rights and delve into more detail on various aspects of these. Thank you for joining us today.